day.
Huh. I have a parted matter in court one. Otherwise, I have submitted the written argument. So whatever he has to submit, he can. My presence may not be. I'll come back from court.
There
one
was
as soon
some
as-
clarifications that we wanted, because you see, this matter is going, whether we like it or not, is going up. So we have got to be slightly careful.
Yes, yes.
You see, one thing is that when the 4 or 5 persons had taken food in their house of PW 17, I think.
Yes. Huh.
Names of those 4 or 5 persons, we don't know.
Not mentioned.
Not mentioned. Now, who are those 4 or 5 persons? If you don't know their names, how do you know they are from Alpha also?
Yes.
So nothing is there.
Only that why I have said about 4, 5 boys is linking up with the other circumstances.
And then that 17 has said that Joya Chutia told her. Now,
Yeah,
Joya
164.
Chutia was made accused.
But not
Acquitted.
Acquitted on what ground? What was the finding of
And
the
no
court?
materials. This is what.
no material.
No material. So there is nothing to say that she had stated that also.
164 only. As
That is
Lordship
not-
Kalita had pointed out.
164 made by whom?
She
Made
has
by
not- she has not stated anything
Tilotama
about-
Chutia.
by PW 17. PW 17 in 164.
164, she has not stated
In
anything else.
164 she has not said it. It's only in the evidence.
Evidence.
It's only in the evidence she has stated this.
Lordship, my matter is on.
Okay,
board
you
in
can go.
court.
You can go, madam.
Lordship,
One thing
I'm
is that one thing we can do. You see, we'll keep it after the vacations
For clarification.
for clarification, because it's quite a sensitive matter in a way. We have basically made the order in a way, but we want clarification with regard to certain aspects. There are 60 witnesses, and as you know, 13 persons have died, 19, 20 have been injured. So we have got to be slightly careful with the facts here and there. There are so many facts.
Just
So
last
many-
time I had stated that the signatures,
Ah.
the 164 statements made by the witnesses, those were not put to them. Rather, the magistrate has come and said, so and so exhibit is just 164 statement of so and so. The signatures of the people who were deposed in the 164, their signatures were not
Exhibited.
It was not proved. So I got a judgment on that.
Okay.
That is one. And secondly, my lord, while going through the cases, I found another judgment. It's that the confession statement. There's a mandate of this, there's a judgment of this High Court. The magistrate has to tell the person who's going to confess that I am not a police officer. So even if you do not confess, I am not going to send you back to the police, to police custody. That question was not done here. In a similar case, that question was that explanation was not given to the accused, to the person who was confessing. So the confession said it was not voluntary.
Okay,
I have
just a minute,
judgment.
just a minute, one at a time. So PW 17 stated that Joya Chutia told her. Correct? Now, no such statement made by PW 17 under 161 or 164 also, correct?
164, man.
161 also?
161. 164, she has not stated anything.
161 has been stated.
No, there's nothing there.
161 and 164. And then Joya Chutia made accused but acquitted,
Acquitted.
as no materials were found against. So the evidence of PW 17 with regard to Joya Chutia is of no use,
It's no use.
not relevant at all. It's an uncorroborated statement. है ना? Then the evidence of PW 30. That five guys, 4 or 5 boys.
Mohendra, yes. Mohendra Kaur. 30, Bhavani Kugal.
30.
Yes, yes,
30.
30. That four,
Had,
five people came.
yes, that
Four, five boys.
5 boys had taken tea. Had taken tea or food?
Food.
Had taken food.
They wanted to have food at our
Had taken
place. and
food
had threatened
under
that
threat. Correct.
That's all,
Under threat.
under threat.
They will say had been given food under threat. Had been given food
But no names,
under threat. Are nameless.
nameless.
Then
The
with
Colgate-
regard to those
Colgate and that Gamucha was seized from this house, from this PW 30.
yes, yes. Colgate and Gamocha and one diary, I think.
Diary
What
is a
is-
separate thing. Diary is a separate.
No, no, diary also was there.
No, in this seizure,
Ah.
with the Colgate and Gamucha, diary was not there.
Okay,
Diary
diary
was,
was from where? Diary was,
diary was my client, Muni Hendik, when he was arrested, he had a diary in his possession. But the diary, it was specifically asked to the IO in cross-examination, what is the contents of the diary? I have not opened it.
so diary was seized from
Muhi Hendik,
Muhi Handik.
appellant in 305.
So IO said that he has not read the diary.
Here's one. Yes, sir, I have no knowledge regarding the contents of the pocket diary,
The contents of the diary.
and it is not even a material exhibit. The diary.
So out here in that bag, black bag, I think,
Like that.
black bag, Colgate, Gamocha,
Gamucha.
only those two,
Only those two.
only those two.
Yes. Paragraph page
Colgate
57.
and Gamocha.
I'll clarify my.
Okay. Nothing else. But then the Caesar list has listed a number of things.
Caesar is a little number of things, but she has stated that only Colgate and Gamucha was in that moment.
Colgate, Gamocha and bag.
Bag.
One of the appellants in this case, he has expired or something? No, they are all that. All the three of them.
All right.
And then you were saying with regard to what you were saying, the 164 statement,
Yes, the signatures.
signatures not proved by signatories.
Signatures not proved by signatories. I'm passing over this judgment, madam, for that. Further, my lord, my lord, that judgment specifically states at para 7.
There are 7.
Para 7, I have marked
Yes.
it. How it is to be proved. Signature of a person.
Just a minute. 1927. 9/7. Yes,
Paragraph 7. Under section 67's Evidence Act, it is necessary that the signatures or the handwriting or so much of the document as is alleged to be in particular person's handwriting must be proved to be in his handwriting. There are recognized modes of proving a signature, and they are by calling a person who has signed or wrote the document. 2, by calling a person in whose presence the document was signed. 3, by calling handwriting expert. 4, by calling a
so
person.
by
who-
calling a person in whose presence the document was signed or written.
No,
So the-
first one. Yes, it happens. Calling a person in whose presence it is there. Suppose the person who has signed it or who has written it, he is for very many reasons, he is not there. Then in whose presence it is done, that can be,
So the
happens in the cases
magistrate
of
has
will.
come.
That happens in the cases of wills. Suppose because the testator has died, but here, my contention is, the person was before you. You had not put his 164 statement to him. But the magistrate has made an omnibus statement that exhibit so and so is the 164 statement of this person. Plus mere
So what is wrong?
no,
Out here?
plus
By
my lord,
calling a person in whose presence the document was signed.
mere exhibiting a document does not amount to proof of its contents.
But it has been recorded by the person
Yeah, signature is not proof, my lord. Signature has to be proof. Who has signed it? Anybody, the person who has signed it, magistrate is not going to identify that person, that so and so has come before me. It is his signature has to be proved. Otherwise, anybody can come and say that give a statement. Yes, magistrate has also not identified the signature or the person.
Huh?
Magistrate, she has not identified the signature, nor has she identified anything about the person. She has just stated in the evidence that exhibit so and so is the 164 statement. Now, how do
So
you
she
know?
has not identified the
Yes.
signature.
So whether Mr. A came as Mr. A or somebody else came, there's no proof to that. So those 164s cannot be taken.
These are the 164 statement of whom?
My lord, 4 or 5 persons. I'll just read it out. My 164 statement of Hogan Buragohai.
Just a minute. Khagen,
Hogan Buragohai.
Bora Gohai,
That is PW 41.
PW 41, then number
One
2.
Simanto Chutia.
Manto. Chutia,
He is
PW?
PW 36. PW 36.
36, number 3.
Keshav Dihingia.
The Hingia, PW,
Keshav Dihingia is 16. PW 16. Then my lord Tilottama Chutia. That is PW 17. Then Padmeshwar Chutia.
spelling of Padmeshwar,
PADMESWAR.
MES,
MES.
Padmeshwar Chutia, PW,
This person has not been examined.
not exam,
Not examined. And Bohagi Kaur.
spelling,
BOHAGI.
B for Bombay,
Before Bombay.
BO,
HAGI.
Bohagi,
Kaur. KONWAR. That is my lord PW 18.
so so are they important witnesses? I don't,
They have not stated anything against me, but the links, the circumstances that she wants to bring, the state wants to bring, that they have stated certain things in 164. Anyway, they have not stated anything in the evidence, but she is trying to pull it as a circumstance, a link in the chain. These 164 statements. Now, my submission is they cannot be taken. Firstly, they are not substantive evidence. Secondly, they have not even proved the signatures of these persons.
what else?
My lord, this voluntariness of the confession, I just found it last month, just small, my lord. This court judgment, because there's specific thing has to
But
be
then I think the court has said that it was satisfied.
exactly, my lord. That is where I'm saying.
Okay,
That is
that
where I'm saying.
aspect.
This is our High Court judgment of division bench, paragraph 30,
Division bench,
division bench,
then
just persuasive value, paragraph 30,
the Supreme Court judgment, okay, anyway.
paragraph 30. From exhibit 8, that is the form of recording confessional statement, it appears that the learned magistrate recorded the following questions put to the appellant and answers given thereon. Number 1, I am not a police officer, I'm a magistrate. The same question put here. 2, you are not bound to confess the guilt. Same question here. 3, during the course of trial, confessional statements may be used against you. Same question. 4,
Just a minute, just a minute. GLT 679. GLT 679. Yes,
Madam, this 1, 2, 3, 4, 5. These
yeah.
questions, same questions have been put in our case. Only thing 6, you confess your guilt, that was not put, that is not required. Now comes the thing, 31 paragraph. After giving the said cautions, these were the cautions. After giving the said cautions and explaining the consequences of making the confessional statement, in the above manner on so and so, the learned judicial magistrate decided to record the confessional statement and kept the appellant in his chamber in custody of his office beyond from 12:30 to 4:30. Therefore, the appellant was given about 3 hours time of reflection after giving in the said caution. The learned magistrate on the first day of production of the appellant before him did not caution the appellant that he was remanded to the judicial custody, that is jail hazard, without giving the said required warning and without explaining the consequences of making confessional statement. Before recording the confession statement, the learned judicial magistrate put the above 6 questions and recorded the answers given by him. In his answer to question 6, the appellant stated that he killed. This is not important. Paragraph 32. Carefully perusing the said caution recorded in the form of recording confession statements, we find that the appellant was not sufficiently assured that in the event of refusal to make confessional statement, he would not be given to the police custody again. This is the same thing that has happened. Therefore, in our considered opinion, the appellant did not get assurance from the court that he was free to confess his guilt, if any, voluntarily, without having any fear of going back to police custody. In the absence of any assurance in this regard, it cannot be concluded that the appellant was free from fear of being sent to the custody of police again. In our considered opinion, the said evidence and the manner in which the confession recorded do not inspire confidence to believe that the said confession statement was freely, voluntarily, and without any influence or threat. This assurance that if you do not confess, we are not going to send you back to police. In our case, it is not there.
Where does it say in the CRPC that this portion is required?
My lord, it is mandated.
Show me, show
It
us.
is mandated because assurance, voluntariness.
No, voluntariness, but where does it say that it has to be stated that it has to be told to that person who's going to make the statement that he would not be sent to the police custody after he makes the statement?
My lord, just. Because why, my lord, why I'm stating that if your lordship comes to this,
No,
No, it is not
I'm
in
not
CRPC.
asking you why.
it is not in CRPC, but why this has come up? Because, my lord, if the confession statement is
Now,
taken,
what will happen? Supposing a person is caught today by the police. Incident occurs today. Accused is arrested today. He wants to make a confession. So they take him straight away to the magistrate at around say 10 o'clock or 10:30. 6 hours time, reflection time is given after all the caution required. And then he gives his statement. Then they send him straight away to the judicial custody according to it. They should.
they
But
should,
where is that provision that she cannot be sent back to the police custody straight away?
after confession. Because he has to be brought from judicial, he has to be sent to judicial.
So what is supposing can he be taken from the police station directly to the magistrate
No,
to record his
no.
confession?
He can be taken, but magistrate has to send him to judicial custody. Then from there, he has to be again brought. After confession, he has to be sent. In fact, my lord, if I remember that October 30th bomb blast case, there two witnesses two confessions. After recording the confession, they were sent to police custody.
Let us see the law. Let us be very clear about this.
My lord, that is actually the test for voluntary. CRPC does not state that. But why?
So does some judgment of the apex court say that accused before he makes a statement under 164 has to be brought from judicial custody? Is
There
there
will
any
be-
judgment?
I can find out. There has to be.
You can find out.
Yeah, there
You
has
see,
to be.
the thing is that you are making submissions before us. Okay. So we are trying to accept what you say. So accordingly, you have a duty to ensure that what you say is backed up by law, not you want the law to be or what you think the law should be.
There is
So
a
what you are
balance.
saying has to be backed up by law. Now, when you say something, you said that it has to be brought from from judicial custody if he wants to make a statement under 164. The provision does not say that.
Provision does not.
Then from where are you saying it? So please, because you see, one thing is that we are sitting here to decide number of cases, not your case only. So please help us, help not only you, but help other people also in disposing of the other cases that are going to come after this case. You see, you have got a duty. Similarly, we have got a duty to pass, uh, judgment, which is correct to the best of our knowledge and ability. So there is a corresponding duty on both sides. So please ensure that whatever you say, when we say that please support it, there has to be some supporting material. Otherwise, every time you say something, I'll have to look it up. I'll have to look it up. means means that you're not sure of what you're saying.
No, as per what has been always held is you have to be brought from the judicial custody. That is the reflection time that is given. In fact, in
No,
the
reflection time.
yes, my lord, he has to be sent.
Anyway, no, reflection time has to be given. That
Yes.
much so we are sure, we are clear. But please show us that they have to be brought from judicial custody. Unless they are brought from judicial custody, you cannot record their confessional statement. Where is that?
There are-
Supposing there
yes,
is a
there-
murder of someone,
Yes, yes, there is.
and supposing, let's take an example, a situation where he wants to confess that it was he who killed that person. Now, if he is not brought from judicial custody, but brought directly from the police station, given 6 hours reflection time, or maybe 2 days reflection time also. And he says that, yes, I killed him with the knife. This is the gun. Now, what will happen? Forget the gun. Say he kills him. He accepts. He says everything. Now, what will be the value of that confessional statement in view of the fact that he has not confessed after being brought from judicial custody, but directly from the police station?
Just to rule out police, because under 25-26 police, anything made before police is not admissible. Similarly, my lord, if you are brought from police custody directly.
No, that is a different issue.
No,
This
if you are brought from police custody directly and you are kept in a judicial.
no, but then no. Supposing he is brought and he says, "Yes, I killed." Then what happens? He said that no, we cannot accept it because you are
Yes,
brought
but that-
directly.
that
from
has to be, because of the voluntariness, why he wants to confess, that's why he's sent to.
Madam, so what he's saying,
That is already there. I pointed out.
no,
the
no,
other
so what
day.
he's saying is that a judicial, a voluntary confession under 164 can only be made after the person is brought from judicial custody and not from police custody.
No, there are, of course, this is in a way subtle position, but then he should be away from the influence of the police. This
Exactly.
No,
is
no,
why,
so is there any judgment which is direct to that point?
there is.
is.
But
Yeah.
I remember I got one judgment from police custody. He was brought and he was made to confess, but he was given reflection time.
Reflection time out here also.
Yes,
What we're
yes,
saying
even.
is that,
Huh.
so the question put to him
Hmm.
is, supposing a person is brought from police custody,
Yes.
he's given reflection time of 6 hours
Ah.
and he makes his confession.
Hmm.
Now, what is the value of that confession?
In my humble submission, he is away from the influence by giving a reflection.
So
So
now,
simply he was
his case is that a confession under 164 would only be valid
Hmm.
only if the maker of the same has been brought from judicial custody and not from police custody.
No, that is
If
not
it-
my case, my lord.
That is
That
what you
no,
were
no,
saying.
No. This judgment says something else. This judgment says the magistrate has to caution the person.
That is a
my
different
lord,
thing.
once
Caution
you
is a
make the
different-
confession, if you do not make the confession, the assurance is, if you do not make the confession, I am not going to send you back to police.
So that is
So,
what,
so that
ah,
is,
that is a
that is
different
the
thing.
fear. That is the
No,
fear of
that-
not going. This is
Ah.
why I got the judgment.
Because in this case, he was brought from judicial.
Yes, yes, that is it. He was
okay,
brought
now
to-
another question
Ah.
is it a requirement that he has to be told that he will not be sent to judicial police custody after a confession is recorded under 164?
And normally
Yeah,
that question is always put, but I don't
No,
have
no,
a
no, not a
decision that if
question.
it is not put.
Well, it's, she appeared for this case in that
He
case.
is,
That's why I bought this. She
Yeah,
appeared.
that question is in a way mandatory.
no, no.
It's in the
Huh?
format only. It's in the form only.
It's not in the form. It's not in the form.
It's not in the form,
not
it's
in the
not nothing, it's not in
If
the
your
form.
lordship, if your lordship takes up the
Please,
one,
please be careful of what you say,
164.
because you see,
it's not in the form. But that judgment says that that assurance has to be given to gain the voluntariness of the accused.
what has happened is in this judgment, this court, division bench of this court, they have decided in 2014. Because they said here that carefully perusing the said caution recorded in the form of recording confession statement, we find that the appellant
Hmm.
was not sufficiently assured that in the event of refusal to make confessional statement,
Hmm.
he would not be given to the police custody.
Form of liability and given to police custody again. So of course, he'll not be sent to police custody is a requirement. And if it is not put,
But supposing the court says,
hmm,
if you give confession, then I don't think that. I don't- what is- You would not keep-
মই আছিলো। নহয় নহয়, ফৰ্মত নাই বুলি কৈছে, I have to check, huh? Oh, mention of the course. Oh. ফর্মত থাকাতে মোৰ ফর্মত নাই।
এইটো question করতে হবে।
নাই নাই, I have.
Madam, is there any form?
Because in the Guwahati High Court rules, there is a form. The form that is always there in the
It is
confessional.
volume 3. If your lordship takes up volume 3,
Yes, volume
I'll
3 is
just point
there.
out how the form is and why this question has to be asked. Six, 661.
That's it.
667, your item.
Uh-huh.
Five, six, seven.
Let the matter be
Okay.
called there.
I don't know, I will just see this aspect.
Uh-huh, yes.
No, volume 3, my lord, the paper book, paper book, volume 3.
Anyway, so the thing is that with the High Court must have published a form.
But that thing is
Mhm.
not there.
That thing is not there in the form.
That police that I am not going to send you back to police.
Then,
Why I'll point it out. It's very clearly stated. Why? Just point volume 3, if your lordship takes up for 2 minutes.
no, in the form made by the High Court,
That's what, my lord.
it's not there.
It's not there.
I have to cross check because
Because
I am not very sure.
the entire form, if your lordship takes up the form, the bold portion, whatever is written in bold, those are the questions that the magistrate asks. And it's a pro forma form. Pro forma form, last part says,
Anyway, we'll take it up after some time.
My lord,
Let us
I'll
take up
cross-check
the
this.
others, because we thought that is 1, 2, 3, that's all.
Lordship, there's a mention is going on actually.
Let them mention, anyone wants
I
to
will
mention, you
mention.
can mention. I know there is one matter we can't take up.
Well, I beg to mention for a listing, bail application. Next week, any day. Next week, any day.
Bail application,
Suspension of sentence, basically. The person is an HIV patient.
so, matter pertains to
The POC,
302, POXO,
no, not POCSO, NDPS,
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 commercial quantity.
commercial quantity. But my lord, HIV patient has a separate act. They should be released or kept away from jail. That's why I want to.
So that they can infect others.
Inside, there's more harm.
Outside also there is more harm, probably intravenous, multiple, maybe he's an addict also.
But any day next week.
Yeah.
I'd like to mention item 4. It is wrongly listed before your lordship, because lordship qualifier was, we have challenged.
Okay, right. List this matter before any of the bench, but not before one of us. Bracket, you write justice. Later.
Lordship, I'd like to mention item number 1. May I kindly adjourn the matter for today, as my senior is not well, Arslan.
Oh. Ar Islam. Okay. Yes, what to do? We adjourn the
Lordship,
matter.
bail application is rejected, your lordship, on earlier occasion. Paper book is ready, your
No,
lordship.
there is,
Please-
no, there is, the I is the item 1.
I think I order has been rejected. I have
Just,
checked.
just, is it rejected? No,
Lordship.
IA will be considered at an appropriate stage.
It was not considered, your lordship.
Not considered, will be considered, yes. IA will be considered at an appropriate stage.
Appropriate stage, but they are not pressing for it, and paper book is ready. Let the matter be prepared.
Paper book is ready or what? The paper book
Paper
ready?
book,
No,
two
okay.
numbers, yes.
So we'll list it for hearing.
Sir, maybe the case taken after vacation.
Okay. Right. On the prayer for adjournment made on behalf of Mr. R. Islam, learned counsel for the applicant appellant, comma, who is reportedly unwell, comma, leaves the matter after vacation for hearing. For hearing. In as much as paper book has already been prepared.
I'd like to mention item 8 of today's list, my lord.
Item 8, yes.
Matter will be taken after vacation, because my lord, this is a matrimonial appeal, and regarding my lord alimony. And a talk of compromise here going on for settlement, my lord. So matter will be taken after vacation.
I am appearing for the opposite party wife in this case, Lordship. Lordship, they have not paid the monthly allowance to the opposite party since last 2 years. Not even a single pie had been
No,
paid by them, your honor.
I paid, my lord.
Lordship,
I paid.
Even you furnish the bank detail. Even
I
after
paid,
that, time and again, honorable this court had directed them to pay the monthly allowance to the wife for maintaining them not paid.
I have the information that my lord, I have regularly paid on our bank
Just
account.
give us item 8.
Bank account I paid.
We'll see if you have paid. If you have not paid, we'll list
Yes,
it on
sir.
Monday.
Okay.
And you have to get all the documents.
Lordship.
Otherwise, we will ensure that some severe order is passed against you.
Monthly allowance, my lord,
Lordship,
my
kindly
instruction up
produce
to
the
the.
order.
Just a minute, just a minute. This is a matter of 2020. Why should it be
No, sir.
adjourned all the time?
As because they have not paid the 20% of the alimony amount before this honorable court.
I have
The,
deposited already, my lord. 1 lakh was the order. I have already completed that amount.
After so many order passed by this honorable court, they have deposited.
And monthly amount, my lord, I am depositing as per my instruction that my lord, up to the month of April, May I have to deposit in the June, I have already deposited.
5 lakhs granted to
account.
you.
5 lakhs was the alimony amount, Lordship, and the monthly allowance was there.
Where?
And I ordered it at 24/11/2021. This honorable court had directed them to pay the monthly allowance.
24/11, this court,
24/11/2021.
24/11/21.
That I am paying, my lord. I am.
Last
as per my
paragraph,
instruction.
Lordship.
Anyway, so the question of whether this 3,000 would finally be adjusted against the permanent alimony of 5 lakhs, that would have to be decided also.
Lordship, that didn't be decided, but the honorable trial court has very much clear in this. Last portion of the judgment may kindly be produced.
My lord,
The
these are the
order-
receipts of bank
Order
account,
and
my lord.
judgment passed by the trial court.
My lord, I am paying, my lord. This is the,
Okay. So monthly allowance was 3,000.
3,000 per month, Lordship. Till the
These are the
payment of
receipts, my
the,
lord.
Huh?
These are the receipts, online payment receipts, my lord. I have already paid. These are the receipts, my lord. This is my February and January, February, March. These are the 3 receipts, my lord.
No,
And
it-
he's saying that, my lord, for last
Three
1 month,
receipts
this
they are
is not
showing.
true, my lord.
Let them file the affidavit, matter may kindly be listed on Monday, each and everything will be given to Lordship. Or not, they may file the
You
affidavit.
you
That's
file
all
your
the-
statement of accounts of which bank? Otherwise, why not we'll dispose of the entire matter on Monday?
Lordship, I have to take instruction, my lord. He's out of station. My client is out of station.
We are out of station
my
with Mr. Counsel. You want instructions with regard to what this is an appeal. There is no instruction required with questions of fact.
Lordship, here in this case, I was appointed as MKS QE Lordship to place some materials before this honorable court, whether the maintenance amount given by him can be adjusted in the permanent alimony or not. So Lordship may fix it Monday or.
No, that is not the question. That can be decided later.
Lordship.
Right now, he's neither paid the permanent alimony fully, and neither is he
Not
paying the rupees 3,000 that
No.
he's supposed to pay.
That is not true, my
Just
lord.
a minute, that
paying.
according to him.
I'm paying, my lord.
So now, we need proof of that.
So, my lord, my prayer is that, my lord, everything, entire matter may be heard after vacation.
No, we will hear whatever, but by Monday, you bring a statement of account, or we'll give you till Tuesday.
He will give her his bank account, my lord. This is my receipts of deposit on bank. She will give her bank account.
Yes, so just show me that, just show me that.
This is the receipt.
Let us see the receipt. Let us see which bank account you're
Yes,
using.
my lord, he has already submitted bank account and I have deposited. And these are the alimony amounts, my lord.
A huge amount were accumulated, Lordship, since last so many months. That is reflected in the order also, Lordship.
So how many
What
occasions-
is your account number?
Lordship,
Your bank account number?
Lordship, I am giving.
Yes, give.
I've also furnished the same to the other party also.
Because the trial court has held that till the 5 lakhs alimony is paid,
Yes, my lord.
he has to continue paying his monthly allowance.
Allowance.
Yes, my lord. That I am paying, my lord.
So the question now, so in that, so with regard to what you are saying, the amicus curiae is saying, that might have already been answered in the trial court order.
Lordship.
We'll see that. We'll see that later on. Account number 300 1020 100 16599. Account number. Name is Sushmita Datta.
Lordship,
Sushmita Datta.
Huh?
Lordship,
Sushmita. The SIS, SUS. There is no H.
no,
Susmita. Susmita Datta. This is Union Bank of India.
Lordship,
Union Bank of India. Where is your branch? Kamrup. Kamrup. What is it? Chamber Road. Huh? Huh? Oh. Acha, now it has been converted. It has been amalgamated
PNB.
with the PNB. Amalgamated, no? And this is, so it is Kamrup Chamber Road. Fancy Bazaar. Okay, right. Oh, you want that it should be adjourned?
Adjourned.
On what ground?
On the ground that, my lord, talk of compromise is going on for settlement of the.
He's
final-
no, he's not agreeing. Well, talk. He's not agreeing. You cannot have a unilateral agreement talk. It has to be a two-way talk.
Yes, my lord.
You see, you cannot dance the tango alone. You've got to have a partner.
For hearing, my lord, I need some preparation. I have to go to the records.
So-
So maybe
so-
after vacation,
Okay, for preparation, but then we'll fix a date. But then you come
after
on. give-
vacation, my lord, date may be.
No, that we're not fixing that. For Tuesday, we are fixing for information.
Yes, my lord. Tuesday.
And if you do not come on Tuesday, then we know how to deal with you.
No, my lord,
You-
I am paying, my lord. This is the
earlier
receipt, my lord.
occasion also, Lordship, the appeal was dismissed for default. So many times they were absent.
No, no, not
And
so
before
many.
the trial court
Only one
also,
day.
Lordship.
Okay, right. Mr.
Yes, my lord.
Acha, hey, out here also on February, your client had appeared in court.
Yes, my lord.
Huh?
Yes, stated
Personal
before this
appearance
court.
was there, Lordship.
Oh,
And
direction to appear
contempt
had been
proceedings
done.
were also supposed to be done against them in this case. For not complying the order of this honorable court.
Ultimately, he has complied, my lord. Due to a financial problem, my lord, he was for last 2 years, he has
So
serving
many
in a
times
private
the order
company.
was passed by this.
Last
honorable court.
during lockdown, my lord, he was not in a position to earn, my lord.
What is he working as?
He is working as a salesman, my lord. Only 23,000, 16,000, 23,000 with bonus he is getting, my lord.
And you're supposed to pay 3,000 a month. Out
Yes.
of 23,000, 3,000 you give.
3,000 I'm giving, my lord.
You're not giving. That is why you were called by the
No,
court.
no, my lord. Earlier, that was regarding alimony part, my lord. Alimony was defaulted, that was,
Anyway, right. What is your name?
yes, not.
Mr. S. Nath, learned counsel for the appellant, is present and submits that the matter may be adjourned as there are talks for compromising the matter with the respondent. Full stop. Next paragraph. Mr.
S.K. Agarwal.
S.K. Agarwal, learned counsel for the respondent, on the other hand, submits that there is no compromise talks going on between the parties. Full stop. He further submits that in terms of the impugned judgment dated 16/7/2019 passed by the family court in FC civil case number 1007/2017, the appellant was to pay rupees 5 lakhs as permanent alimony to the respondent. And the appellant could cease to pay the monthly maintenance allowance after full payment of the permanent alimony had been made. Full stop. Next para. On perusing the order dated 24/11/2021 passed by this court, we find that the appellant was directed to continue to pay the monthly maintenance amount of rupees 3,000 to his wife, with effect from November 2021. Full stop. Next para. The case of the respondent being that monthly maintenance allowance is not being paid by the respondent, comma, we would have to see the veracity of the same through statements of accounts to be furnished by both the parties. Full stop. Accordingly, the appellant shall submit statement of account with regard to his yours is SBI
SBI.
with regard to his SBI account number XXXX 5356. From when have you not been paid?
Since last 2 years, Lordship.
From
whose
November
amount-
2021. From November 2021.
Whose amount has been accumulated?
From November 2021. Full stop. The said statement of account would have to be certified by the manager of the said bank.
No, my lord, in some cases, I have paid to the family court also, my lord. Prior to that,
Was made by this honorable court, Lordship.
No, we'll
For
see.
depositing
Let,
the amount in
just
the
right, just right one thing, just right one thing. The counsel for the appellant submits that some payments were made directly to the family
family
court.
court, my lord, yes.
Full stop. Accordingly, the appellant shall produce the receipts issued by the family court with regard to the monthly payments of rupees 3,000 made by the appellant. Full stop.
Lordship, in the year
Obliged.
2021, specific direction was made by this honorable court, and accordingly, we have furnished the bank details to the other side also with the petition that the honorable court had directed to furnish the bank detail. Accordingly, their huge amount
Prior
were
to that, my lord,
accumulated,
prior
Lordship.
to that, we submitted before the family court.
Lordship, in the Tuesday.
It is
instead of
there, my lord.
Because they will file the
The
affidavit.
appellant shall specifically state the dates on which the monthly allowance of rupees 3,000 had been given to the family court. And the same should be supported by receipts.
Yes, obliged.
Deeply
Tuesday.
buried, Lordship. Matter has been
Both
fixed
of
on-
you bring, we'll see.
Matter has been fixed on Tuesday, Lordship, for the final hearing of the matter, Lordship. As well as for the. Deeply buried.
May I please, your lordship? Lordship, I am appearing on behalf of Mr. A. Kalita,
Item,
item number 13.
yes.
Lordship, I beg to mention for item 13 for adjournment, lordship.
Why?
Lordship, due to some personal difficulties, he could not come to court.
Whose personal difficulty?
Lordship A. Kalita, Anjan Kalita.
On the prayer for adjournment made on behalf of Mr. A. Kalita. Any objection?
No, my lord.
Lordship, we have taken consent.
On behalf of Mr. A. Kalita, who is having some personal difficulty, and as the same has not been objected by Miss
B. Bora.
B. Bora,
Lordship.
learned counsel for the appellant. This is the matter after the vacation.
Obliged, lordship.
Now you say on the prayer for adjournment made on behalf of Mr. A. Kalita, who is having some personal difficulty, on the prayer, and which is not objected to by Ms. B. Bora. This is the matter after the vacation.
In this case, the LCR is arrived.
Item,
Item 2.
LCR has arrived. So
Yes.
the paper book has to be made.
Hmm.
Okay, right. Counsels for the parties are present. Full stop. They submit that LCR has arrived. Full stop. And I just need to prepare the paper book accordingly. and list the matter after 4 weeks.
May I pray one thing, Lordship? In the cause list, my name may be shown as SD Purkaister instead of my full name, Lordship. In 1 or 2 pages, full names are shown.
Okay, right. Registry to reflect the name of the amicus curiae in the cause list as SD Purkaister.
God bless you.
Why doesn't he want the full name?
Paper books
Huh?
have prepared and served, my lord.
What?
Paper book has
book
been
is
prepared
ready.
and served, my lord.
Okay, right.
I've got it.
Parties for the, causes for the parties submit that they have received copies of the paper book. Accordingly, release this matter for hearing
Gotcha.
after vacation.
At the outset, I would like to tender my apology. That time I had to go because
No, no,
Honorable
no.
No,
it's not a
Honorable
problem.
Chief Justice wanted us to deliberate on the issue whether notices are required to be issued to the victims.
Aha.
So we prepared and AG was also called, Mr. Goswami was also there. So
And
we
what was
had,
the final decision?
by reading the rules and the other guidelines and everything, now according to rule number 4 of POCSO rules, it is the duty of the police officer or the juvenile unit or the support person to inform the victim about all the proceedings. So of course, order is reserved. Lordship will pass the order.
Some practice directions would be issued. So perhaps therefore these appeals may be kept pending till then. Perhaps the intimation either in a form of a notice or the learned chief justice is also of the opinion maybe an impediment by keeping the identity confidential may be required. So some practice directions.
A direct notice from the court might not go. It will be the duty of the public prosecutor to inform the police officer and police officer will do
What
the
is
same.
important, my lord, your lordship would recollect in all the cases, what has been emphasized is the right of participation of the victim, and especially in cases of sexual offences like POCSO. Even under the POCSO Act and the rules, the law clearly mandates that the victim has a participatory role because, and therefore.
So
that-
there is no bar on the participation.
Correct.
But
Correct.
how will they come to know? They'll have to
So
come to know.
therefore, To effectuate
So-
that right, a notice needs to be given. Now, how and what that. the
High court
practice directions
judgments are there, Supreme Court judgments we don't have on
Delhi and
POCSO.
Bombay has several directions.
I think our judgment is also there.
Yes, yes,
Yes,
Baramati case. I
Bormoti
think.
Payeng, this was the core of the contention.
There, your lordship have distinguished between informant and victim. And your lordship said, in case of victim has a right. So victim may always with leave of the court can come forward. I remember, I read that.
Perhaps a proviso will
The,
come in
the problem arose because of this accused
Hmm.
who was initially in Arunachal.
Yes.
He went to
Changed
Daman,
his-
he went to
yes.
Daman Diu.
Hmm. I've
Now,
seen in the
because
facts.
notice could not be served upon that person,
Matter was getting delayed.
then everything also, that this is one practical difficulty that can happen in all cases.
Yes.
Because these persons, they shift,
Hmm.
and usually they are from the lower strata of society.
Yes.
They shift their residence, then what to do? You can't keep track of them all the time.
Therefore, I find, my lord, in 1 or 2 cases of Delhi High Court, there is a procedure laid down. Suppose our victim is not found, then a report has to be given. And based on that report, if service is not possible, the court can proceed on. But this is in relation to a victim, not informant.
Yes. Only in
Even
POCSO cases.
Jagjit Singh case, Supreme Court, it is very clear, informant victim different. Informant has no right of impediment, but victim has a right to participate. It is that participatory.
Supreme Court judgment is in consonance with your lordship
Yes,
judgment.
correct.
No difference.
Similar.
Perhaps a proviso will be added in the Guwahati High Court rules, making an exception in POCSO cases.
Item number 10 to 20.
No, he is rising for 2 minutes.
Okay, 2 minutes.
Entire confession. I have to
Now,
say-
while going to the field, while being taken to the field by that Diori or whatever.
Jatin Dawari.
Jatin Diori. He mentioned somebody's name, I think.
Leela Khan,
Leela Khan.
only Leela Khan
Only
name is
Leela.
there amongst the
He mentioned
appellants.
4 persons' names, but only one is convicted.
Amongst the appellants, only Leela Khan.
And the other 4 were also made accused,
Accused, letter.
all of them only. But Leela Khan was convicted. On what ground?
Leela Khan. Conviction.
What are the basis?
On those grounds, conjoint reading of all the, without specifying, but a
Exactly.
conjoint reading of all the,
Because she was taken to the field.
along with others, along with some other, even his name was stated by Joya Chutia in her 164.
Huh?
Joya Chutia, Tilottama Chutia in her 164 said that Joya Chutia has taken Leela Khan's name. Leela Khan name appears only in two places. One in Tilottama Chutia's 164 and the other in confession.
In a confession.
In whose confession?
The Jatin Johari's confession.
Jatin Dawari's confession.
One who was taken,
Jatin Johari's confession and PW 17's evidence,
not evidence.
164.
not evidence.
In evidence, there's nothing about anybody.
Yes.
In evidence, substantive evidence, there's no name of anybody.
Just give me the volume one.
Seven.
This
Page number 40,
Page number?
40. And I think she was
Very-
re-examined.
May I read it, my lord?
No, page
She-
40 is, this is PW 17.
Page 40.
In
Volume
fact,
140.
Huh?
yes, 40.
Volume
And-
1, page 40. Tilottama Chutia, PW 17.
She was again re-examined.
I know
42.
accused Jatin Chutia, accused Joya Chutia, and accused Apsara Barua. I do not know the other accused persons. Incident, Leela Khan is the other accused person, one of the incident took place on 15 August 2004. At that time, I was studying BA second year in Dhemaji College. On 15th August, there was a bomb blast at the college street. A lot of people got injured in the bomb blast. Some persons died. Police examined me with this regard. I do not know how the bomb blast had taken place. Cross was declined.
Then there is a re-examination.
Then re-examination, her 164 was brought. In this case, earlier I had given as PW 17. I also gave statement before magistrate. Exhibit 46 is by signature. That's all. In this one,
Sorry, in page 42.
42 is a re-examination. Re-examination.
Where she has mentioned about 164.
160.
Justice Kalita has on the other day had pointed out, unless she says something in her examination in chief or re-examination, simply we cannot bring facts from 164 and add it.
Correct.
Yes, sir, they're very vital.
There was some judgments.
But then Lordship knows the facts and circumstances of the case. Now, at least she has said that I have stated, I have given my 164 statement. I do not remember what I have said, but then I have given. That is how I brought that 164. It's a peculiar to the facts and circumstance.
But this cannot be said to be substantive evidence.
No, not substantive, only corroboration.
Only corroboration, but to corroborate what,
With-
there's nothing
with
to
what?
corroborate.
With what?
That's the only problem. So in the section 164 statement, Leela Khan's name comes.
Yes,
Leela Khan. Just-
Where is,
I'll
where
just
is this,
confirm, my lord.
where is this, 164
it's
statement?
in volume
My
3.
lord, Volume 3, page 624, I guess.
What is it?
624. Yes. 6. No. Look to my one.
Acha, it's there.
620.
Yes. 624.
620. What does it say? I am a student of BA final year in Dhemaji. My elder brother Dilip Chutia's house in the direction of the railway station, and one can reach his house after going some distance after crossing the office of irrigation department at Iradhal in Dhemaji. I am studying in Dhemaji College, staying in my elder brother's place. On 14th August this year, I reached our house at Merajan. Joya Chutia is my cousin, that is father's elder brother's daughter. In the evening hours on that day, that is 14th, she came to our house to switch TV, and upon meeting me, she told me in a hushed tune that a couple of days earlier, one Alpha member had taken refuge in their house for the night, and that said youth had told her that there would be bombing in Dhemaji on 15th August. I had not trusted her words, or even if I had trusted, I had not divulged it to others out of fear. She had mentioned the youth's name as Leela Khan. That's all.
In Jatin Johari's 164 statement or evidence.
160
Confession.
no,
164.
confession.
164 confession, sorry. So confession.
He said Leela Khan was one of the persons.
So this also,
And as of,
it's slightly difficult for us also. I mean to, because, I mean, how did the trial court come to a finding?
This Lordship have seen in volume number
My-
2,
my
they
lord-
have a conjoint
my
reading
lord,
of everything.
the
Entirety of evidence, all those
That is
Marutika, all
Entirety
those
of evidence,
videography.
entirety of disjointed evidence, which has no connection with each other.
that is paragraph 124 of the judgment, impugned judgment at page 495. It is from the above
Just
analysis
a
of
minute,
evidence.
page
495.
495, yes.
Para 124, it says, from the above analysis of evidence on record, I find accused so and so to be members of Alpha, this. This just mentions about Caesar, about the law under Kashmira thing of 164. So above conjoint reading of everything,
They have relied on the
Relied on.
videography, the.
videography cannot be
Caesar of
relied. I have given,
Marutika.
Videography, what
No,
videography?
Lordship.
the
I-
search.
Can we see the videograph?
No.
Can we
This
see the
is
video?
such a material exhibit, I think.
Right.
It's
not
not
a
a
material
material exhibit.
Videography is in respect of,
And then
That's
that
search and
65,
65B is not there.
yeah.
Admittedly, it's not there. My lord, the video, CD, cassette, whatever, that has not been made a material exhibit,
Not exhibited.
not exhibited. It's
it
not a
can be
material exhibit.
checked in the judgment.
Fine,
sir.
fine, only-
Depends on
Not
the-
exhibited, 65B not there.
Not there. Fine.
I don't know, you please check.
No, it's
Yeah,
not
the
there.
judgment itself says, my lord, page 506 of volume 2. From there, all the exhibit list is there, entire exhibit list. The exhibit list does not mention about any videograph material exhibit. It's only documentary exhibits.
And
506 to
video-
509.
Videography is only in respect of search and seizure made in Dipanjali Borgohain's house.
But that was what?
Not
Search
What was seized out there? Bag,
Hmm.
Colgate.
No, this is from the house of
House of Dipanjali. There's nothing they could find. Just a videograph.
Dipanjali, nothing.
Yeah, there's nothing.
There's
Dipanjali,
nothing.
That was
Because-
Babani, I think.
Yes, that is Bhavani, right?
Ah,
right, that's
Bhavani.
Bhavani.
Colgate
no,
and,
those
huh?
one gun or
One-
one
No gun.
knife,
No, one
Dagger.
knife, my lord,
one
And one
dagger.
bag.
one bag. And evidence against me, Muhi Hendik, appellant in criminal appeal 305. It is that I used to call Dipanjali sometimes, or she used to call me. Call records, they said we had seized the call records, not exhibited. Call records not exhibited. 65
And
certificate not there.
what about the calls made to that alpha leader?
Who is
This
that
is
alpha
what,
But there was a name, no?
That
There
is
was a name mentioned, but then there was no call records.
no call record. Call records have to be first proved by as per the 65B, mandate of 65B.
no, call records are there, numbers tell is,
Numbers
but
tell,
what they
numbers tell.
spoke.
But
That
what you
is
spoke, that's not
contents.
there.
Call records are Muhi Hendik making calls to Dipanjali, Dipanjali making calls to Alpha members. Those numbers are there. But then what were the contents, of course,
But
is not there.
Those records cannot be taken because 65B is not there. That's the mandate.
You see, supposing they are call records, that your number shows that it has called this particular number.
Mm.
Now, in the absence of 65B, will it have any value?
65B needs to be there. So independently, if your lordship goes to the circumstances, case will never be made out, I mean, for the prosecution.
No, we have,
So
you see, we have to go independently. And then we have got to connect each independent fact or evidence with the other fact. It cannot, they cannot have, they cannot stay in separate compartments. And then try to say, yes, since they are all in this big fat room, they have to be joined together.
They're difficult by the strict application of law, but yes. 65B certificate I've searched.
Okay,
it's not there.
okay, how do you link up those 4 or 5 boys who had food in PW 30's house with what had happened?
No, because those husband and the brother of, they were also accused.
Correct. But for
And-
who were the 4-5 boys?
It happened before the incident. They had come and taken shelter.
Shelter, how? What did they do by taking shelter?
Those facts are not there.
They said
Only
that they said that the house owners had to give them food as they were threatened.
This is what he said, threatened.
And even if it is not threatened, okay, they had food, so what?
But threatening for food,
No,
not for
no,
shelter.
no. Leaving aside, okay, so supposing they were not threatened, supposing they were willingly given food.
Hmm.
What does that show? What does that imply?
No, the conspiracy that was hatched because.
But who were there? There's no
who
evidence.
They is not there. But coupled with other evidence
When did they come to that house?
before the occurrence.
Before you went, and
When
what
is-
what were they doing? Were they carrying some weapons? Were they carrying, I don't know, some bomb or what? Nothing
There was
is
a
there.
notebook also, but then that is not, doesn't say what are the contents there.
Anyway, I think anything else
Lordship has my written argument, I think. That
we have got, but then what
Uh-huh.
about this
difficult.
division bench judgment?
For that, I need some time. I have to see whether that violation would vitiate the confession itself
Correct.
and whether that is in the rules.
And whether this judgment can stand scrutiny of the Supreme Court judgments, I don't know, and the
Yes,
CRPC provisions.
this is a new point which he has not raised yet.
He has not pressed, but
I
he's
don't
pressing it down.
Admitted.
Yes, it's a law point. Anytime it can be raised. So let me go through.
Yes, yes. His basic stance is that since they were not
Hmm,
told
Hmm.
that they would not be sent to police custody after the confession,
If they do not.
If they-
confess.
or if they don't confess. So since this caution had not been given to them, accordingly, whatever they have stated is under duress,
Not voluntary.
not voluntary.
That is,
But then in our case, the magistrate wrote that it was voluntarily made.
Correct, and he was
Exactly, my
satisfied.
my lord, that
But
is where-
that is what now he's saying.
that is a
that-
type format. That's a type format.
Huh?
And if your lordship takes up volume 3, this will be very clear. Just takes up volume 3, the
But This is
confession.
how they write.
Yes.
It is in the
I'll point it
format.
out, my lord. I'll point it out. Volume 3, if your lordship takes up for 2 minutes.
Volume 3, yes.
If your lordship comes to page 661. This confession starts at 661, goes up till 671. If your lordship sees,
661.
One.
Yes, 661, yes.
if your lordship sees this form, things which are written in bold, those are written by the magistrate. Everything else is a type pro forma. Now your lord, records will say that. If your lordship comes to page 666,
Yes,
point C. This is a pro forma. It
Yeah.
must be clearly understood that a questioning of an accused person in order to discover if the making of a confession is voluntary is not a mere formality. The magistrate must apply his mind judicially and endeavor to base his finding upon definite premises and grounds. So direction is magistrate has to judicially apply his mind. Fine. If we come to page 669. If we come to page 669, second paragraph, he says, I believe that this confession was made voluntarily made. This is a type format.
This is how they write. I
Yeah,
believe.
This is a type format. If it-
I
then-
believe.
Then,
so she must have read it and.
no, ma'am,
signed
next
it.
page,
Ah.
next page, 670, next page, 670. Point 8. Brief statement of magistrate's reasons for believing that the statement was made voluntarily. Where is that reason?
That line will show. So,
It's a type format, it's a type format, no. I believe that the confession was made voluntarily.
then
Ah.
it was taken in my presence. There are other stipulations, other.
Where is the application of judicial mind that this is made voluntarily? It's a type format. It's a peon can sign it then. Why a magistrate is required?
I'll bring that format from the criminal rules on the next day, then we will be clear.
Magistrate's reason of voluntariness. Satisfaction of the magistrate that yes, he has come voluntarily.
No, the subsequent sentences, sir, about the previous one. Previous page.
A2. The type
Then
format,
it
that
is
is what I'm
taken in my presence and hearing.
Yes,
it
it's a
was
type
read over.
format. It's a type format. See the record.
I'll see. I'll bring that
My
format.
lord, confession statement, anything which is not in bold is a type format. Records will say that. Whatever is in bold has been written by the magistrate by his or her own hand.
No, by writing by the hand is different. But then she wrote it, she had said, and it was typed out.
Okay, I'll withdraw this submission if it can be shown that the magistrate has applied his mind with reasons that this has been done voluntarily from this document.
Reasons are not required as long
My
as
lord,
this
this
is
says,
that.
this pro forma says, she's relying on that, pro forma says. This says, point eight openly says, brief statement of magistrate's reasons for believing that the statement was voluntarily made. This, point 8, read with
These
point
are
6.
guidelines, these are
Guidelines,
guidelines.
No, only thing is that the magistrate should say that
Ah,
he or she believes that
Exactly.
that she's satisfied that the statement was voluntary. That's
Where
enough.
is that? Where is that, my lord? That is what, this is a
I
type
think
format.
I read it somewhere.
This is exactly
Have
right.
you?
This is a
no,
type thing. This is what I'm saying. Paragraph page 669.
I
Page
believe that the
669.
confession was
I
voluntary.
believe that this,
669.
see, this is a type format, my lord. I can show from the records.
So what
This
is wrong?
type, it's a type pro forma. Magistrate is just simply saying, where is the application of judicial mind?
No, but then if the magistrate was having a different view, the magistrate could have clearly stated.
Exactly, man. Then why this same thing?
See,
Same document.
when we sign orders,
Exactly, my
when
lord.
we sign orders, we have read it and we sign
My
it.
lord,
So
we
it
have to
come- it
take this
comes-
document, we have to take this document fully. We cannot take one point and reject another. What does point 8 say then? Brief statement of magistrate's reasons. Where is that reasoning? Where is the brief statement of magistrate's reason?
Anyway, those are anyway.
Anyway, I'll bring
Yes.
that format itself. This will make things.
Yes.
clear.
I don't, anyway, there are other issues that are more important than that.
Not required to go to.
Not
such.
required to go when they don't really make any material difference.
If a case is.
Because what was stated in the statement under section 161,
164.
164 had not been made during the evidence. They had only exhibited those 164.
Hmm.
So that exhibit does not cannot be said to be a substantive
No,
evidence.
not at all.
Not so. How does it matter? Why
This is
why
for
should
the
we go
confession.
into?
This argument is for a confessional statement.
What?
They need that.
Yes.
Put efforts on that, the other evidences are lacking.
Yeah.
Yes.
Then
We're just saying because otherwise we're going to devote around maybe 30-40 pages to that. We're trying to look at a shorter way of doing
Yes.
what we're supposed to do because you see, as it is, you've got 3 volumes
Yes.
out here.
No, in fact, 313 had
316,
taken a lot of pages there, but volume looks it's bulky, but then it's okay.
60 witnesses.
Yes.
only fewer.
After the vacation, I'll point out these.
Yes, yes. So in the meantime, I think more or less we know the facts of the case. So only a few minor issues that have to be looked into and
Yes.
clarified. That's all.
That's all.
I think yours is basically 164 now. Nothing else.
Yes, only on 160.
Okay, right. Heard the counsel for the parties, list the matter on
Any day, 17 to 21 or 24, 25.
24th or 25th?
24th. 24th,
Right.
as part heard.
Part.
Public.
Public.
What happened to 6 and 7?
5, 6, 7 are together.
Oh, 5,
Yeah.
7, 5, 7. Okay.
This is an amicus curiae matter by the criminal appeal.
Huh?
Criminal appeal, my lord,
No, this will come with me.
though I have read it,
No, no,
but
that's right.
Well, it's an appeal against the conviction order judgment, my lord, by the session judge. Judgment and dated order dated 2012-19.
Yes.
Where the case in the FIR is the informant with the deceased used to live with a deceased from his childhood nephew of used to stay with him, and he was found dead, and accordingly an FIR was lodged. Though in the content, the accused was not named, in the format of the FIR, I find the accused has been named, and that is how the
Who is the accused? Parent?
accused is a friend of the deceased.
Deceased.
They are all co-villagers, and the victim, the deceased used to stay with the informant from childhood. Nephew. The
Informant is the
uncle.
nephew.
Informant is the uncle.
Informant is the
Yes.
uncle.
One eyewitness is there. Only thing, my lord, on this point, whether because in the FIR it says it doesn't mention that so and so has killed my nephew.
Not required.
Not required, my lord. Very well, whether I can place it. Otherwise, I thought on another date because I wanted to see that part once. But if it is all right, that I can proceed. Otherwise,
No, unless you can show some citations that
I thought
the
of
FIR
taking
has
that
to
one.
reflect the name of the assailant.
Well,
How will anyone know everything? All crimes are usually done
so
in the cover of
it says that he was informed by phone and all, and there's an eyewitness, and they are all co-villagers. So otherwise the Ijahar is very simple. It says humble submission is that last night at around 9 p.m. my nephew, age so and so, who was staying in my house since his childhood, was found dead with multiple injuries in suspicious condition at so and so under the jurisdiction of so and so police outpost. That so and so was immediately informed about the same. I therefore pray to take necessary legal action in this regard. Nothing is mentioned. But in the format, I find the accused name is given at serial number 7 at page 2. Only I wanted to be just clarified. Otherwise, there is an eyewitness, though there is nothing to doubt. Otherwise, the rate of the eyewitness, but still there is some contradictions with her 164 that may not be very relevant, but there is some as regards. Here she says it was the accused had the eyewitness saw the accused hitting the deceased with a bamboo stick and a dowel. The injuries to the head and everything are sharp weapon. In 164, no weapons are mentioned. And before court, she says that he informed this immediately to PW5 and PW7. But both PW5 and PW7 in their evidence doesn't say that PW6 the eyewitness has informed them. So some kind of contradictions are there. So I actually, my lord, I was preparing for the other matter before one yesterday.
So you tell me what do you
Any
want?
day, my lord. Tomorrow also I can do it. Sorry, my lord. Monday.
Tomorrow
also I can- Monday I
tomorrow we're not coming.
Monday also I can do it. No problem, my lord. I can do it Monday, Tuesday, as your lordships pleases.
I think Monday already list should have been.
List is out.
Tuesday.
No, next week though, I think. Next week though, you all will be very busy, I think. All your senior counsel
Motion,
will be-
perhaps it will be a motion week.
motion week.
It's already declared.
Already declared motion week.
Yes.
So, adjourn it on after vacation,
My lords.
right, on the prayer made by the appearance council, which is not objected to by the additional people.
Next.
This is the matter after the vacation. But what about this,
Next is also his.
huh?
Next is also his.
My lord, your lordship wants some clarification.
Item?
No, in this matter, your lordship was saying something.
No, this is item.
Item number 9.
No, it's okay.
9. And then.
Yeah.
Look, this is the POXO appeal. So here I find that on 2nd March 22, it was admitted, LCR was called. And it says no formal steps, no notice was otherwise issued, but it says that it is open for the victim to participate, but no notice or anything has been issued otherwise. Now that issue has come up, maybe your lordship may take this up also after the vacation, my lord.
We can take it up now also.
This, my lord,
Judgment had not come.
There's no order.
but otherwise, my lord, this I have not seen today, my lord. That matter I had seen, that is why I said I can do it next week also. This I'm sorry, my lord, but It will to us, Rohit. I'm not sure. Alright. This is the one I put my daughter, section 16. I committed that act on.
Six-year-old.
6 years old, my lord. And in fact, medical report also suggests, which is at 59, recent use of force and all that, my lord, is there.
Though she has said the accused, you have to, the thing is gone. Close,
Oh, yes, the
live
online.
streaming, live streaming. Put it off.
One matrimonial
Poxo matter.
matter,
Yes.
one matrimonial matter was aired online
Ah.
and it made an